So I'm going to delve into the fun and exciting world of wills, estates, and trusts, and with a particular focus on issues you'll want to address when planning for a loved one with a disability. I'm going to go through things very quickly, so I apologize for that, but I want to highlight as many of the issues that you should be considering as I can. And of course, I'll leave time for questions, or if you have questions along the way, don't hesitate to raise your hands. So just very quickly to, put a little fun spin on estate planning. These are top 7 estate planning myths that we see come through our office all the time. Obviously, there's a lot of misinformation out there and about what you should and shouldn't do when estate planning. Number one, we see all the time, especially with a spouse, a surviving spouse, they're often told by a well-meaning friend or family member to go put all their assets jointly with an adult child. It'll avoid probate and it'll make things really easy. They won't need a power of attorney. Well, the Supreme Court has actually ruled that assets held jointly with someone other than a spouse are presumed to be that of the deceased and will actually be brought into probate, unless there is evidence that the deceased meant for that asset to go specifically to that child. So it's often a strategy that doesn't work. And there's other risks that also arise that I will talk about in a moment. Spouses, unfortunately, often think that they don't need powers of attorney, that they can just manage each other's assets, and that's not the case. If there's real property that's held in both their names and a spouse has become incapable and the other needs to sell or mortgage that house, they will not be able to sign for the other spouse. A parent does absolutely have the right to appoint a guardian for a minor child in a will, but that appointment is temporary. It only lasts for 90 days. After that time, anybody can apply for guardianship of the child. So we do suggest that parents put in writing their reasons why they appointed who they did in their will, as well as their reasons why they may not have appointed other people in their lives. That is evidence that can be put to the court because the parents won't be there to speak to the issue themselves. People are often surprised to learn that marriage actually revokes a will at the option of the new spouse, and they're not often in it, so they might not be inclined to let it stand. We'll get into probate because people are always interested in probate fees. Absolutely avoid it where you can, but it isn't the be-all and end-all. Common law spouse. If you die without a will, a common law spouse will not be entitled to a share of the estate. Many people assume that if you've been living together for a long time or have a child together that you have the same rights as a married spouse, but when it comes to estates, you don't. And as we'll get into as well, a parent does not have the right to appoint a guardian for an adult child in their will. That's only something that a court can do.
Just a quick question.
Yeah.
How is 90 days determined if you appoint someone to be your guardian?
90 days from date of death.
So why is it 90 days? If you want that person to take care of your child, why is it taken away from them after 90 days?
The law has decided that decisions with a child should be made at the time in the child's best interest, and you might have prepared that will 5 years earlier, and that person is no longer appropriate to care for the child. So the court wants to retain the jurisdiction to make the decision at the relevant time. Of course, great weight will be given to who the person who the parents did appoint in their will, but it's not a guarantee that they will end up with guardianship of the child.
Can you list successors?
Yes.
Like after the 90 days, it can go to another guardian?
Oh, no.
Okay.
No. Sorry, I thought you can list who you want. If they're not able or willing, then you can have somebody else.
No, it's
but
not. You're trying to stack.
yeah, exactly. Good strategy.
Doesn't work.
Yeah. Do you have a question?
Yeah, so when you go through a guardianship process and you identify somebody there that's separate from the will,
Yes.
That doesn't have a 90-day...
Oh, no, like an appointment of a guardian by a court? No. That's only for a minor child in a will.
Okay.
Yeah. So just very quickly, estate planning is an important gift you can give to your family. So many reasons to have a will. You definitely want to avoid this. But at the end of the day, you want to maintain control over your assets, how they're distributed, and who acts for you as executor. I'll touch on the capable part of this in a moment, but every capable adult should absolutely have a will. We often hear, well, I don't have any assets, I don't need a will. Well, everybody has something, even if it's just household goods. We all have social media accounts like Facebook, and everybody files taxes. So dealing with those issues alone is made a lot easier if there's a will and an executor is appointed to deal with those things. Having a will, of course, is especially important if you have minor children. Appoint a guardian, include trusts so they don't receive their entire inheritance at age 18. If one of your beneficiaries receives ODSP, you can include a trust, a special Henson trust, so that their ODSP benefits aren't affected. There's certain assets we can pass through a secondary will to avoid probate. If you have real property outside of Ontario, you should consider a will in that jurisdiction dealing only with that property. I just highlight those issues to hit home the point that there's an array of estate planning options that can be tailored to every unique situation. And I want to reiterate, I don't want you to just do, any old estate planning. I want you to do proper estate planning. That means it should be comprehensive. The lawyer that you work with should ask a lot of questions and request a lot of information. Best case scenario, they work with your financial planner so that they can confirm how you hold your assets, who you've named as beneficiary designations, because that's the only way we're going to know how assets are going to flow and whether the terms in your will can take effect. For example, if you have a Henson trust in your will, you want to make sure there's assets that are going to flow into your estate and to fund that trust. If you hold all your assets jointly, or you've named beneficiaries, you might not actually have any assets coming into your estate. So the lawyer should explore all those things. And your estate plan, this sounds cliche, but everyone's unique. Your estate plan should be as unique as you are. You don't want to be pigeonholed into a cookie cutter approach. It's not a fill in the blanks kind of situation that you're after. So ask your lawyer what their process is. Do they have a checklist that you have to fill out where they ask you all these questions? If you have a special issue like a child with a disability or a corporation, ask if they work with clients with similar situations. Don't just focus on cost, as you may get what you pay for. When I spoke to a capable adult, what I'm referring to is a test of mental capacity to sign a will. So there's a specific legal test, whether someone has the mental capacity to sign a will. And it's not a clinical diagnosis, it's a test of whether the person has the ability to understand and appreciate the information that's relevant to making a will. So this legal test has developed in the case law. There are other tests of mental capacity as well for signing POAs. Those are set out in a statute, but for testamentary capacity, it's developed in the law. You have to know your logical beneficiaries, who the world would think you'd leave your assets to. You have to be aware of any support obligations that you may have. You have to know your assets and their approximate value. You have to consider who you're appointing as your executor and whether they're capable of doing that job. So how it works in practice is generally the lawyer will make an informal, we're not capacity assessors by any means, but we are not, our professional rules dictate that we shouldn't have someone who we feel is incapable sign a document. So we'll make an informal assessment of capacity. If we're uncertain whether the client has capacity, or we're concerned that there could be a possible challenge to the will because of testamentary capacity, we will suggest that a formal capacity assessment be done by an assessor who's certified by the province to perform capacity assessments. Testamentary capacity doesn't actually fall under their mandate because it's not part of the Substitute Decisions Act, but it is accepted that they can perform tests for testamentary capacity. Everyone always wants to know about probate. So what probate actually is the process of putting the last will of the deceased before a judge and having the judge bless, for lack of a better word, and confirm that that is the last will of the deceased and that person, the executor, does have the authority to act. And why we need probate is it allows us to deal with certain financial institutions and certain assets. So the financial institution holding the deceased assets will advise whether they require probate. And why they would require it is they want the certainty in knowing that they are paying the deceased asset to the right executor. They don't want to pay over that investment and then have someone walk in the door the next day and say, whoa, I'm the executor for that person and you paid the investment to the wrong person. Or if the deceased owns real property, in order to deal with that real property, we will require probate. And the result of applying for probate is the court issues what's called a certificate of appointment of estate trustee with or without a will. And they've attached a tax to that it's now called the estate administration tax. It's about 1.5% of the value of the estate. You get a little deal on the first $50,000. It's only $250, and then it's $15 for every $1,000 of estate value after that, with no upper limit. So what assets are probated? So any assets in the deceased's sole name come into the estate, as well as assets where the estate was designated as the beneficiary, so maybe an assurance policy that was payable to the estate, that comes into the estate. And any jointly held assets with someone other than a spouse where we don't have evidence that that asset was meant to pass to the joint owner. So all those assets are calculated for probate values. What doesn't come in are assets that are passed in a secondary will. There's certain assets that you can do that, and I'll explain those. If you've designated a living individual on an insurance policy or as beneficiary of your RRSPs, they don't come into probate. The value of real property outside of Ontario doesn't come into probate, and any mortgages on any real property in Ontario, you don't pay probate fees on the value of those. So there are ways to save probate fees. There's different strategies like the secondary wills, which I will talk about, and naming a beneficiary. Like I said, if you've named a beneficiary, that asset passes outside of the estate and we don't pay probate fees. It's just important to make sure that we don't want to save probate fees at the expense of our other estate planning goals. Like I talked about, if you have a trust in your will, sometimes we're going to want to name the estate as, say, the beneficiary of a TFSA, even though it means paying probate fees, because we've got to get some assets in the estate in order to get them into the trust. And just a caution on joint ownership of assets, it's generally okay between spouses. Someone other than a spouse, though, there can be capital gains issues that arise. You're also opening up the asset to the potential creditors of the other joint owner, or if they go through a marital breakdown and there's a division of family property, it can be caught up in there. So the takeaway is, let's look at the big picture. Let's not open ourselves to other risks or lose sight of our overall estate planning goals by solely focusing on probate. So I mentioned having 2 wills. So that's a valid estate planning strategy to save probate fees, meaning that an individual can sign a primary will and a secondary will. And through the secondary will, there's certain assets we can pass and we can avoid probate on those assets. So they include shares in a privately held Canadian-controlled corporation, as well as household goods. So if you have significant antiques or book collections or something like that, or cars, we can pass those in a secondary will, and that doesn't require probate. Another way, I'll just explain this quickly, but if you have a significant insurance policy that you want to get into the estate, possibly to get into a Henson Trust, an insurance declaration is a nice way to I'll go back to the beginning. Where you've named an individual as the beneficiary of a life insurance policy, 2 of the benefits of that are you avoid probate fees, and the proceeds aren't available to any creditors that you may have on your death. We can do a special insurance trust declaration where we flow the proceeds into the estate and into a trust in the will, and we name the executor as the recipient of the life insurance proceeds, and then direct that they hold it upon trust on the terms of the trust that we have in the will. And we can do that and avoid probate fees and maintain creditor protection. So that may be a strategy you want to explore with your lawyer if you have insurance coming into your estate. I know you went through the RDSP session, but just a quick note to say, you want to make sure if you have if you have a loved one with an RDSP, that you would like monies either from your estate after your death or from your assets while you're living, maybe by a power of attorney. If you want your executor or attorney to have the ability to contribute to that RDSP, I would suggest that you give that authority in your will or your power of attorney document. Otherwise, it's questionable whether that would be an authorized investment by an executor or an attorney, so best to have that set out right in your documents. And it is possible, and I think Richard was going to touch on it, but you can roll over RDSP or RRSPs to RDSPs. And you can also, in some situations, roll over an RRSP to some life annuity trust, which can then pay into an RDSP. So just some, we like to include clauses in your documents, A, to alert your executor to these possibilities, and B, to give them the authority to do that so it's not questioned by anyone. And I'm sure Richard mentioned it, but just also note that any monies left in the RDSP on the death of the beneficiary actually goes to their estate. So if they have the capacity to sign a will, that's best case scenario. Otherwise, it is going to pass according to the intestacy laws of Ontario. Yeah.
If they don't have the capacity to make the decision, and there's a substitute guardianship in place, so is there a possibility to do a will at that point?
No, even if they are, even if someone becomes their power of attorney, court, there's no, a court-ordered guardianship, the one thing they can't do is make or change a will. So, no, if an individual doesn't have a capacity to sign a will, there is no other option.
So the monies in the RDSP would go to the province? Or?
No, so we'd look to the law as to where the money would go. Firstly, it would go, the first $200,000 would go to a spouse. The remainder would go to children, parents, siblings. There's a list in the law that we go through. The government only receives it if there are no living relatives of the beneficiary. Yeah. Did you have a question? Yeah.
I was just wondering, for our son who would not be capable of signing a will, then there's no way to have a guardian, if we're gone, appointed by court to be able to have to get those
Just on his death.
on his death.
Yeah, he can have a court, he can have a guardian, but they won't be able to make a will for him.
And he can never have a will.
No, so he will never have a will.
We can't, as his guardians, make a will.
No.
Okay.
Yeah. Yeah.
Okay.
What if we take our, it depends on the level of the disability. What if we were to have your adult child accompany you to the lawyer and have 2 wills made up at that point?
If the child does not have capacity, the lawyer should not allow them to sign a will.
So what if they do that test? We bring that capacity slip
Oh,
with us?
and they have capacity? Oh, absolutely, yes.
Okay, so the first step is to get the capacity assessment done. Then
You could meet with a lawyer, like I'll meet with clients and meet with the individual with a disability and talk about things. And if I think they're capable of signing a will, I'll absolutely do that. If I'm not sure, then I would go
get them to,
have
you
them
have reference referral numbers?
to capacity assessors. Oh, absolutely.
Okay.
Yeah.
Sorry.
Yeah.
Whether the beneficiary cannot have a will, is the court or is the doctor? Who makes the decision?
Who a capacity assessor.
Or there's capacity assessor, which is independent from the provincial government, independent from the power company, is another kind of authentic administration.
Yeah,
Capacity, yeah, they're certified and trained by the province to perform capacity assessments under a particular piece of legislation. But they will do assessments of capacity as to whether you can sign a will or not.
How often you can ask the re-assessment? Like, can I try this year and then next year the beneficiary becomes better at my well-being?
Capacity fluctuates. You can be capable in the morning. You can be incapable in the evening. And but when you look at where the law is coming from, at 18 we're presumed to be capable,
Yes.
and we all have the right to make our own decisions. So the law does try to preserve that as much as possible. So your capacity can fluctuate throughout the day. And it also depends on the decision that needs to be made. You might be incapable of signing a will, but you're perfectly capable of deciding what you're going to eat and wear that day. Right? So there are different tests of mental capacity for various decisions to be made and different actions, like the test for mental capacity for signing a power of attorney for personal care is much lower than signing a power of attorney for property. Okay.
I think you just answered my question, but the legal age for a child to sign the will is 18.
18 for a will, 16 for power of attorney for personal care, and 18 for property. It's 16, yeah. Yeah.
But if you go see a lawyer and the lawyer is satisfied that the person understands,
Sure.
then you don't have to have this attachment.
No, only if you're concerned that someone might question whether the individual did have capacity. So it depends on the circumstances. Yeah.
The parents for the child is automatic guardianship decision.
No, parents are not automatically guardians. At 18, any authority the parents had ends. Now, there are certain decisions, Healthcare Consent Act, so medical decisions, they may still retain the authority there to make medical decisions and admission to long-term care. But outside of that, no, they don't have the authority.
Disability child. This disability child still after 18 the parents needing documentation.
Yes. The law doesn't differentiate between adult child with a disability and, any other adult who may or may not be capable. So I know that's difficult. It's hard for parents to hear, understandably. So I will get to the different substitute decision makers. I'll go there quicker because it seems to be the topic everybody wants to talk about. So we'll just talk really quickly about this. Appointing an executor, one of the big decisions you'll have to make. It's a very difficult job. Some of the duties of an executor can take up to 18 months. Very intense in the first 6 months or so. Towards the end, we're just waiting for paperwork from CRA, but you can be personally liable. Many people mistakenly assume it's an honor. Not so much. It's a very big job. They are fiduciary. They must always act in the best interests of the beneficiaries. I can't stress enough how important, if you're acting as an executor, to keep good records of everything you do with the assets of the estate, all decisions that you make. If at any time any of these decisions are called into question, you want to have notes as to why you made a particular decision and so on. And communication with the beneficiaries is key. It's all about managing expectations. That can go a long way to avoiding any disputes with the beneficiaries. An executor can be paid. It's about 5% of the value of the estate, but it's a calculation done based on all the transactions of the estate. It is taxable income to the executor, and at the end of the day, compensation has to be approved by either all of the beneficiaries of the estate or a judge on a formal passing of accounts. Let me touch on trusts, just because this may be something of interest. So if your kids are getting towards the age of applying for ODSP, ODSP has very strict limits as to how much a recipient can own. So receiving an inheritance outright can have disastrous effects on their ODSP. A way to avoid that is to include a Henson Trust in your will for the benefit of the ODSP recipient. Because of the nature of the trust, the fact that the trustee has absolute discretion how much to pay, to whom to pay, and when to pay, the court has decided that it should not be considered an asset of the beneficiary. So it doesn't matter. There's no maximum amount you can have in a Henson Trust. It won't affect ODSP. Now, payments from the trust will affect ODSP and still have to be within ODSP guidelines.
Now, the Henson Trust, does it, when can you set that up? And do you need to have funds flowing into it as soon as you set it up?
No. So most people include them in their wills. So it's drafted in your will, but it doesn't come into being, it's called. It's not funded until your death. You can set them up while you're living, but generally it's a method to pass on an inheritance. So it's in your will, but it doesn't actually exist until you pass away. So for tax purposes, a trust is considered a separate, oh, lost my slide, it's okay. It is considered a separate taxpayer. So they recently changed the taxation of trusts. Now across the board, whether a trust is set up during your lifetime or upon your death, they are taxed at the highest marginal rate of taxation. There are certain exceptions, and a Henson Trust can be one of those exceptions. It's called a qualified disability trust, and one of the criteria is that the beneficiary has the disability tax credit. So in that case, the trust will be taxed at graduated rates like we are. Now, a person can have more than one Henson Trust, so they could have one from mom's estate and one from grandfather's estate, but only one of those Henson Trusts can be a QDT and receive favorable tax treatment.
What if you have two children?
They could each have their own Henson Trust. So, yeah.
So it's not just one and then they're both done?
You could. You could. I would set up one for each. Yeah, I would do one for each. Choice of trustee is as important as choice of executor, perhaps more so because of the absolute discretion that they have. The person you name it as your executor can continue on to the role as trustee, or you may name a different individual to take over at that time. You can name more than one individual. They can do the job jointly.
What happens on their demise?
Important to list, I would appoint a list of alternates. So, you know, if person A can't do it, person B. And I often suggest to clients that each of the major banks has a trust company component. It is more expensive and it is less personal, obviously, than a friend or family member. However, even as a final alternate, knowing that continuity will be there is nice peace of mind.
So if my son gets money put into a Henson Trust, and 5 years after we die, he passes away,
Yeah.
and he doesn't have a will, what happens to the money in that Henson Trust?
A properly drafted Henson Trust will specify where the funds are to go upon the death of the beneficiary. Yeah, so we'll go back to the will, and the terms of the Henson Trust will specify that. Yeah. Yeah.
So the Henson Trust is that it will fall to the executor to set it up.
If you don't say otherwise, yes. Yeah. Yeah. It sounds complicated, but really a trust can own any assets that you can own. So the assets are just held in the name of, in trust for, in the name of the trust, or sometimes for real property it's actually held in the name of the trustee, because for legal purposes a trust is nothing more than a relationship. It's only for tax purposes that it's a separate taxpayer. So a trust can own a home. That's often a nice way to set things up, because then the trust funds can pay for any repairs and expenses to the home. An ODSP recipient can own a home without affecting their ODSP benefits. The difficulty is paying for the expenses. So if you pay from the Henson Trust to the ODSP recipient to pay for their home, that is included in the $10,000 of income in any 12-month period.
But if they have to do repairs or something to the home, and it's more than the allowable 10,000, then you run into a problem.
Absolutely. But when the trust owns the home, there's no problem, because the money doesn't have to pass through the beneficiary's hands. Yeah. So that's a workable solution for a lot of people. Yeah. Yep. Yep.
With a living interest, so that your
the child can actually live there. But
Yep.
the woman.
Yep.
But the gift over to somebody else.
Yep.
So on their thing,
Mhm.
it passes to somebody else.
Yes.
How do you compare that arrangement as opposed
To the Henson Trust. The benefits to putting it into the Henson Trust would be that if a time arose where it wasn't practical or in the child's best interest to keep the home, it could be sold and the proceeds could stay in the Henson Trust for their benefit. If it's a life interest, if it's no longer appropriate for them to live in the home, that asset's going to go to somebody else. So it depends whether you want the funds tied up in that home to be available to the loved one with a disability or not. Yeah. Yeah.
When you mention Henson Trust,
Yeah.
does it then implicate that there's an issue with capacity? Right? By virtue
Nope.
of saying, no, okay.
Nope,
Does it not?
because people will include Henson Trusts for a spendthrift beneficiary, so someone who's fully capable but parents have concerns about. It just means that the discretion for how the money is spent lies with.
Discretion as opposed
Yeah,
to capacity.
exactly. Yeah. So no, it doesn't trigger anything. Just a quick. So if an ODSP recipient receives an inheritance and the will didn't contain a Henson Trust for their benefit, there is a different type of trust that they can set up so as to not affect their ODSP benefits. Now, it is a maximum of $100,000, and they can set it up themselves, but if they don't have capacity to do so or a capacity to sign a power of attorney for property, we may be looking at a guardian of property. But it is an option if, you know, grandparents or other loved ones didn't know that receiving an inheritance was an issue. That is available. I'm going to jump right to powers of attorney because this is kind of cute, so I'll put that in there because it does speak to the authority that a power of attorney for property has. So. An attorney, in this case, is a substitute decision maker. Poor choice of words because we all think of a lawyer, attorney. But in this case, in Ontario, we mean substitute decision maker. So it's someone that we appoint to deal with our finances and our assets should we not be in a situation to deal with them ourselves. So absent specific conditions in the power of attorney for document, in the power of attorney document, your attorney for property can do anything with your assets that you can do except make or change your will. So it's a very powerful document. So choice of attorney is key. Now, generally, the power of attorney for property will be drafted such that it can be used while we're capable or incapable. More often than not, it is used when the grantor, the person who signed it, is perfectly capable. However, they may be at a point in their lives where they're no longer mobile to get out and do their banking, and they're frankly okay with someone taking that on for them. Or maybe they're out of country for 6 months and want someone to deal with their assets while they're gone.
What if you have a power of attorney, appointed power of attorney, and they become incapacitated? Does it go to your secondary?
It does. So appointment of alternate attorneys is important for that reason.
It's not that they pass, it's just that
If they're incapable of acting, yep, or maybe not willing or able for whatever reason, we would pass to the second.
I'm going to hang on to it no matter what?
No.
Okay.
Like
if they become incapacitated?
yeah, no, they can't do it.
It'll go
Yeah,
to the
it goes to the
secondary.
next. Yeah, yeah. Choice of attorney is key. What happens if you don't have a signed power of attorney for property? Then we're looking at alternate substitute decision makers. So in this case, there are a few different options. If the only asset of the individual is some government benefits like ODSP or OAS, those programs will informally appoint a trustee to manage those benefits. So if you have a child with a disability and all they have is ODSP to manage, you may that may be the only substitute decision maker you need in order to manage the ODSP for them if they're not able to sign a power of attorney for property. Now, filing income tax returns can be an issue. A lot of parents do it online, and it doesn't seem to be an issue. Problems arise if you have to deal with CRA. They may question your authority to speak on behalf of your child. So you may be looking at a guardianship. There's two different guardianships for property: a statutory guardianship and a court-appointed guardianship. Statutory guardianship, what happens is a loved one can request that a capacity assessment be done of an individual who they are concerned is incapable of managing their finances. If the capacity assessor finds them to be incapable, that triggers the PGT to becoming the statutory guardian for that individual. And then a family member can then apply to take over from the PGT. There's no guarantee that the PGT will accept your application and hand it over. However, it is a less expensive process than court-appointed guardianship, and it is a process you could do without a lawyer if you chose to. If you want to go the court-appointed guardianship route, that is an application to court to be appointed as a guardian of property of somebody. There is you would need a lawyer for that process, and there's two routes. The lawyer can appear and speak to the issue, or if it's not going to be contested, the materials can be put before the judge with no formal hearing, and he or she reviews the materials and decides whether they'll grant guardianship or not. The materials would include an affidavit, which is a sworn statement. It sets out the story of the incapable person and why they need guardianship, what decisions need to be made that aren't being made, and why guardianship is the only course of action. It's the least restrictive. There isn't a course of action that's least restrictive on the person's rights. Because from the perspective of the court, at 18, we're all presumed to be capable of making our own decisions. So when the court is granting guardianship, they view it not from the perspective that, oh, I'm helping these parents, manage help their child manage their assets. They're looking at it from the point of, oh, we're taking away rights from somebody. So they want to be sure that we're not doing this unless it's the only way to help this individual. And you would also need to submit a capacity assessment by a certified capacity assessor.
Is that
Yeah.
for 18 and over?
Yeah.
Would that be the same for
No. No.
you would have a separate thing?
Yes. So you can do it in one application, but you're requesting two appointments. Yeah.
A capacity assessment,
Mm-hmm.
could it be a psych report that clearly states this individual is not?
No. It has to be a certified capacity assessor. Yeah. Yeah. Yeah.
And rough guess in terms of I've heard twice or three times that it's a very expensive process to appoint a guardian.
Guardianship?
Guardianship. Is it?
5,000-ish.
Yeah.
Yeah. Yeah. And the process, if it's on consent, the materials will first go to the PGT, the Public Guardian and Trustee, and be reviewed by their lawyers, because part of their mandate is ensuring that the Substitute Decisions Act is the provisions are given effect, and that's the legislation that this falls under. So there will be back and forth with the Public Guardian and Trustee. No, we don't like that provision, or no, we want to see this in the order. And part of the order will include a periodic passing of accounts. So if you become the guardian of property of your child, likely every 3 to 5 years, you will be required to put your accounts in proper court format and put them before a judge for approval.
So did you allude to the fact that this capacity assessment can cost up to $5,000?
No, the court guardianship. The process of hiring a lawyer to apply for guardianship, not the capacity. Capacity assessors set their own rates. It's more in the hundreds of dollars, sort of, yeah, depending on how long they have to meet and writing their report. But yeah, no, that should be like sub 1,000-ish. Mm-hmm. Now, on the personal care side of things, so personal care covers these various issues. Now, we'll jump right to what happens if you can't sign a power of attorney for personal care. Medical treatment and admission to long-term care is covered in the Healthcare Consent Act. So in that act, there is a list of people who can act as substitute decision makers. So if your child is with a doctor, the doctor needs a decision made and they don't feel that the child has capacity to make that decision, they will turn to the substitute decision maker. And in the act, it's guardian, power of attorney, spouse, children, parents. So parents are on the list. So those decisions could be covered. PGT will not step in as guardian of personal care, only as a last resort. So that statutory guardian where we can trigger the PGT and take over for them, that doesn't exist with personal care. There's kind of a gray area to those other areas where if you need a decision made in those areas, we're going to the court and applying for guardianship of the person. Similar application is made, and like I said, often if you're going for one, you often will try to go for both if there are decisions to be made. And for personal care, you actually need 2 capacity assessments. If you're going the non-hearing route. I don't do contested ones, so I'm not sure on that has different evidence requirements depending on the situation. Those we often see, less so we see those with family members with a loved one with a disability. It's more where it's mom or dad has become incapable and children are fighting over who gets to be power of attorney. It ends up in the court and the court's going to decide who gets to be the guardian. So those are the ones that there's a hearing on more often. Yes.
So like say a husband and a wife?
Yep. Yep. Yes, absolutely. And again, appoint alternates. If you are going for guardianship, it ends on the death of the guardian, however. So if it's mom or dad, they pass away, it may require sibling or another loved one from starting the process over again and applying for guardianship. Okay.
So that can't be like already done as an alternate?
No, there won't be an alternate. You could apply mom and a sibling, say, we have done that before to make sure there is someone more the age of the child with a disability. It is an option.
Sorry, on your
Yeah.
to a
Yeah.
guardianship, essentially.
You can.
You can, eh?
Yep, they can be joint, and the court can order that it is joint, like everything's joint, or they could order that certain decisions or certain assets are managed by one and other assets or decisions are managed by the other. When you sign a power of attorney for personal care, it can only be used if you're incapable. And like I alluded to, your capacity can fluctuate during the day. You always maintain the right to make decisions about your person. So we only turn to your attorney for personal care if you can't make those decisions for yourself. So this is a summary of the substitute decision maker. So when I meet with often parents of an adult child with a disability, we'll review their unique situation and have a look at the decisions that need to be made. So what decision have the parents run into that they're not able to make on behalf of their adult child? And from there we can make a determination of what substitute decision maker makes sense for them. Firstly, of course, our best case scenario is that the adult child can sign powers of attorney. That is the easiest and best route. But if they can't, on the property side of things, then we have to look at, okay, so what assets does the child have? Maybe a trusteeship of their ODSP will suffice for the circumstances. If not, do we want to try the statutory guardianship route and trigger the PGT and try to get it back from them? That also avoids the court passing of accounts. You will have to submit your accounts to the PGT for review, but it's a little less onerous than undergoing a court-ordered passing of accounts. And if that doesn't, appeal to the parents, then we're looking at a guardianship application. On the personal care side of things, we don't have the statutory guardianship option, so we have to look, does our decision fall under the Healthcare Consent Act? Will that be enough? Or are there decisions outside of the Act that may have to be made? So we're looking at court-appointed guardianship.